When it comes to development within an area of outstanding natural beauty, well then you've got the additional protection provided to national parks and AONB land, areas of outstanding natural beauty land. There's also, and I haven't got it in my mind at the moment, but there's something about development. I think you talked about the Infrastructure Act, and I seem to remember that there's, there are quite clearly limits to where fracking can take place in such areas. So the point is that in order to, we need a causal link. We need scientific evidence which shows that there is a risk to human health, but also the fact that either the regulatory bodies know that there is a risk and have gone on regardless, or they have shut their eyes. They've been taking a blinkered approach. They haven't considered the matter for themselves. And in those circumstances, you can challenge them for not taking action, or you can challenge them for having considered the matter but gone on regardless on the basis that their approach is irrational. So I'm going to wrap up really, in as much as I've given you a kind of a very rough and ready kind of idea of how in the Frackman case, the matter was challenged, there were objections, and it doesn't have to be a fracking case for that process to be undertaken. You'll all be going through it, albeit with slightly different arguments and different evidence, which is particular to your area or the particular type of extraction method. Going back to acidisation, there was a report by the Environmental Audit Committee, I think, in the House of Commons, which was quite useful on the definition of fracking. And again, there was a concern raised there about acidisation not being part of that definition. I can't recall quite what was said, but I think the committee wanted to bring that acidisation within the definition. But anyway, I haven't talked about environmental impact assessments, but you need to, there are certain limits in terms of the development and the number of, the quantity of oil or gas that one is going to produce from a particular site. That make it a requirement that an environmental impact assessment is undertaken by the developer. And I think it's really important if you can get some technical advice at the point when that assessment is undertaken, or even before, when the local authority is considering what it should include, then that would be really, really helpful. And there are, obviously, there's a network of organisations, so I'm hoping you probably know the obvious people to go to for that kind of assistance. But going back to the Frackman case in regard to the quadrilla operation, I think they were very clever, quadrilla, in massaging the figures so as to ensure that and it's understandable. I mean, I'm sure every developer does this. They don't want to paint a picture of massive development when they can paint a picture which kind of really shows a much more limited impact arising from their operation. But I think that that environmental impact assessment that went before the inspector really just, it was so limited in its scope, just looking at the exploratory phase. And with no regard to what exploratory phase was going to lead to. What was the purpose of the exploratory phase? In fact, one could say that the exploratory phase was it was a 3-year extended well testing period, where Quadrilla were pumping gas into the national grid. Might in fact have covered most of the gas that they were going to get out of those wells anyway. So it was it was production in disguise, and that was the argument that we ran in the High Court. I seem to remember that, me coming out with that phrase at some point. So production in disguise. So because exploratory the exploratory phase was going to get an easier ride perhaps than the production phase. And so, it's really worthwhile just looking very, very carefully at what is being said in the environmental impact assessment and kind of testing the rationale for the development set out in those documents. I mean, they can be very technical, and lengthy. And if you, as I said, if you can get some assistance, then please do. I mean, I'd suggest you should. As far as representation is concerned, I mean, there are a lot of barristers out there who are very experienced in environmental work, and there are some good firms of solicitors, some of whom I work with, who are, they all ultimately need to pay their mortgages, and so they'll be looking for some funding. But there are some solicitors out there who work at very, I'd say very reasonable, but very reasonable for lawyers rates. We half the work I do now is crowdfunded, and half of that is paid at a rate which a lot of barristers and solicitors won't work at. So there are barristers and solicitors out there who will do the work because they think it's really important, but they do need to be paid something, because we also do a lot of pro bono work where we absolutely get nothing. But you will find there are solicitors who are very committed to your cause, and barristers likewise. So, don't think that you're necessarily on your own, because you're not. And if you can get some local politicians involved too, well then there are other ways of stopping this kind of development. And the first port of call is to really energise your local politicians and perhaps stop it at at the first base before you end up having to bring people like me in. So that's all I wanted to say. There's probably a lot more I could do, but thank you. Bye.